certain views from being expressed. We're seeing it with the Church of Scientology that was raised earlier. They're trying to shut down systems that have carried allegedly secret information about the church. And I think we're getting into the thick of what these issues mean to us as internet users, us as either members or future members of the legal profession, and just members of the public.
Andy raised a point which we glossed over, that it's easy to come up with the minority part of this, and failing to see that it isn't simply the minority that is the issue here. Each state has a different data privacy act. There might be some information, and I can't come up with an example right now, we have to study 50 data privacy acts. That might be public information in one state, and private in another. And now we have the same type of problem, dealing with nothing more than information. 20 years ago, when I worked in D.C., there were problems with Eastern Bloc countries considering a lot of data that we publish in our statistical abstracts. They consider that private, like the number of cows in some part of Poland. Well, they may not have wanted the world to know that they were having problems with their economies. They consider a lot of information private that we consider public data. Now, so if I get on that and send Richard a message that the production of wheat is down in some part of Thailand, or whatever, Thailand changed, I can't remember the countries there or whatever. And the next thing I know, there's a knock on my door from 2008 Poland Noriega on me.
Yeah.
Tell me it can't happen.
Well,
Because it does happen. And that's where the problems come in. It isn't simply pornography. It's a far broader issue, as you...
And the double-edged sword is, obviously, as Dan had talked earlier, the internet was devised to not be centrally controlled, which is truly the beauty of the system. The downfall of that system is there is no central control that can keep others from exercising illegitimate control.
One of the things we're talking about doing in our system to address what you just said is to actually have certain information that's only accessible from within our confines versus off of the internet. We had dial-up access, and the majority of our use right now is through the dial-up access. Well, obviously, as this grows, we will hope that the majority will be coming in off of the internet. If we were to define our community loosely as those who dial in, as opposed to those who telnet in, or God forbid, web in, which is a whole different issue, we can actually create certain components of our system that are only seen by account holders and by people who dial in. The best example of the account holders is the materials we get from the National Public Telecomputing Network. They are only available to our account holders. They're not available to anybody who browses us off of the web. And that way you're almost starting to say, this is our community. This is what's here for our community. Somehow we figured out some community standard, so it seems to be okay. And those coming in from the outside in other ways don't have access to it, so we're not liable for their reaction, use of, or anything else. I personally think it's a zoo. I don't think there are real clear answers on that, but I think we're scrambling like crazy right now to cover our rears. And to be honest with you, it's nice to be the first free net in Virginia, but I'd rather there were 5 more in front of me who went through this first.
Well, I guess the first question would have to be what are we charging the vendor with? I mean, if you're waiting until Joe gets back to Memphis and opens the book, I think any activity that the vendor in California has had is over.
We could have an argument the case here. It was over. The minute he opened it, it was put on the water. The actual command was executed in California. And the data was put on the water in California.
I guess my gut feeling, which, you know, isn't worth a whole hell of a lot at this point, is that the actual crime, if you're going to call it that, of obscenity, occurred in California where the computer was located, where the command to download the file was issued, similar to buying the book. If you're going to charge them with obscenity, the obscenity charge happens when the book is sold and the material is distributed. My feeling is that if the material is then transported, I guess I don't see how you can then connect that back to the vendor in California and charge him with a crime in Memphis, if we're talking about buying a book in California, bringing it to Memphis, and then discovering its pornographic content.
Unfortunately, if you compare two bits and a pipe, things I have that I see differently is, in the cases you speak of, and all this is brand new to me, the learning process existing as you see it, is that I don't consider the judge that did the conviction to be incompetent. I would tend to side with the decision on the basis of the conviction. Secondly, if they're trying to cut through all the issues, I don't believe that was an entrapment. I don't see anything that the district attorney did as being violated of any rights from the rights. If you want to flip the civil side, and you want to then argue with community standards, that's a different game altogether. If you're looking for jurisdiction, I would submit that the crime occurs when the recipient becomes a victim and where it happens. If you look at the telephone criminal laws, it's either where the call initiated or the call is received is the proper jurisdiction, assuming the state attorney will talk about it as ours. When you start talking about censorship, if you have government funds that you have received from the internet or whatever,
Which we don't.
then I would consider it, which is consistent with the maybe unfavorable comment I made earlier, that a sysop operating a computer program is, for one, an analogy, running in his own home. And if he chooses to allow visitors, and he has the right to bar visitors of any type, kind, basis, whimsical, or otherwise, so long as it doesn't constitute a violation of race, sex, etc., I think you're all right.
I think, first, our funding doesn't come from any government entity. It comes from a bigger entity, and that's called corporations.
Well, submit you're okay, because you're running as a private enterprise. However, the flip side of the issue is, when you boot that computer up and hook it into a telephone line, and then go out and promote actively, as is done here, publicly, to invite participation, that's where the issue arises as to what degree of constraint do you have, the availability to promote. The flip side is, just as I had remarked earlier, if you're going to run a computer, you're going to run a program,
driver of the automobile probably knows his liabilities and the history behind them a lot better than I do,
Well,
because of the case history.
the conversation thus far, and the discussion thus far talks in terms of cyberspace. And I do recognize it's an intangible, if you will, but it's not truly intangible. And laws have been formulated to control new technology, new concepts and ideas, and have been drawn from all the principles in the law. And I see a compatibility and applicability to this. However, there is one issue that tends to be lost, and that is the issue of security. It's a different perspective, but you're the system. Okay? How will you secure your system?
From what?
Hackers.
You can't. I'll state that flatly.
We think we can, but there are obviously differing opinions on the answer to that question.
The front page of the Wall Street Journal last week, a security company whose sole purpose, and they've been quite good at it up until now, I forget the name of the particular company, their computer was seized, not physically, but control of the computer was seized for a day and a half. Every single one of their proprietary programs was copied, deleted from the company's hard drive, and then distributed to competitors. This was a company that up until now had promoted itself as one of the most secure sites on the internet. Now, obviously there was a big loss of face involved. But the larger issue is, at every level that you're going to have a secure system. And it's the same idea with cryptography. I mean, basically, you want to make it secure enough to discourage some level of interference. A dedicated enough hacker will be able to infiltrate a computer, given enough time, given enough resources, whatever. And we're starting to find that sophisticated hackers are getting into the computers that they want to get into. It's why the US government won't put classified information available on the internet.
I think, but the other issue we have to look at, and I agree with what Rick just said, when we have this symposium in 10 years, it won't be called the internet. I mean, right now what we're waiting for is for somebody to figure out what the National Information Highway is really going to be. And the internet is too old, it's too slow, it's too busy. I think we have to look beyond the Unix-based system that we're currently operating within and look to the next generation. Yeah, there are hackers out there, and they can certainly do whatever they choose to do. I'm not worried about that. Any hacker who wants to spend time trying to get into our system is wasting a lot of time. He can dial in as a guest. I mean, it's not a big deal to get into ours, but certainly it's a big issue on security, as you pointed out. But I think that the next phase of the technology infrastructure is going to address 20 years of experience, and hopefully will take us into the next arena, which was not designed for people, hackers, and it was designed for education and government 20 years ago. I think we have to look towards that, not look to what's here today.
A rebuttal and a counter example to the gentleman's comment, rebuttal to the analogy of using a person's home in comparison to the responsibility of the sysop. Controlling who comes in your door of your home is one thing, because individuals bodily can come through the portal, one 180-pound bag of water at a time, which is the packet of a human body. The rate at which packets enter the portal on a machine that has dial connections, which are going at all times. The including FreeNet has 150 simultaneous user capacity, plus internet connections. So you have all those doorways into that home, and those packets come through at such a tremendous rate that it is technologically infeasible to monitor those packets and what is in them, and it's economically to supply the manpower to manually monitor what those packets contain, evaluate them, and determine subjectively on the spot whether or not to let them through your doorway into your home. And the counterexample would be the public square in a town. Is the police department responsible for every person who wants to run nude from the college campus across public square and protect the people of that community from being exposed to the flesh of some sophomore? They can't control how often that happens. They just catch it when they see it.
Unfortunately, we only have time for one more question. And back.
I just want to agree with the assessment that no matter how good security is in any system, someone else beat it eventually. We just had a security expert in California, in a district security company, who had his private file raided a couple months ago, and he was supposed to be one of the best in the world, and they broke into him. But I don't see how that the worry about that is any different than the fear of someone breaking into this building and going through professors' files in their offices. If someone really wanted to get in here and was skillful enough and had the technology and the ability to jig the window, break the box,
It's called a cat thief.
go to the front, they could. You can never make it secure enough that it's an isolated place.
Just two quick words on that. I think the main difference, though, is that I know what faith I can put in a lock or a door or a window. The average user, perhaps, does not understand the inherent instability or insecurity of their computer. And that once they get into a networked environment, most users are not aware that others have access to their files. And that a diligent hacker would be able to get at this, read their email, look at their files, look at their briefs, look at their pleadings, look at their client files. So I think once you get the average user up to a level that they can equate encryption, passwords, whatever, with the doors, the windows, the locks to their offices, then I think you've achieved that parity and you don't have a difference. Right now, I think there's a general naivete among most users in most communities that are now becoming networked that says, I think I'm pretty safe. You know, I think it was the Detroit Freenet that was shut down by a 12 or 13-year-old hacker from Minneapolis for 3 or 4 weeks.
Well, the FBI and the CIA have determined the Detroit Freenet is located on an Army base, and its Unix machine sits in the same room as the Army's. They're not connected. But a 12-year-old from the University of Wisconsin went across state borders and hacked into the operating system of the Unix machine and got access to the shell and just started deleting stuff and sending stuff out from that domain and all kinds of nasty stuff. Initial newspaper account said, oh, machine at Army base hacked into, and it was a machine located physically at Army base, was not an Army machine, it had no military content on it whatsoever. However, the 12-year-old, as it turns out, was able to do what he did because he was supplied with some very fancy algorithms by a known hacker that the government's been after for some time now. So there's more to that story than met the eye.
Unfortunately, we're out of time, so I guess that wraps up our community activism roundtable. Are we taking a break?
We'll take a quick break. We will conclude with the look at the law and hopefully get some kind of answers or approaches to answers. It takes a little bit of time to convert this stuff to HTML to put it on the web. We will take care of that. But you can expect to see much of the information that was presented today on the web within a couple of weeks. Most of you should have our World Wide Web address. If you don't, you can come and check. One of the LTA people will be glad to share that with you. Also, many of you who filled out registration forms indicated an email address, and a couple of us have asked, instead of exchanging volumes of business cards with everyone, that if we would publish a register of those who had participated in the symposium along with an email address if provided, that we would be glad to do that. With the proviso that if anyone explicitly does not want to be on that list for any reason, that you can definitely indicate that to us and let us know, and we will not put you on that list. Simply, it will be a great way of kind of expanding everyone's contacts and continue a lot of these dialogues virtually after we leave this afternoon. With that said, if you do not want your name on that list, We'll have someone outside in the atrium following this. You can just put your name on a piece of paper, and we'll make sure that you don't actually get put on that list. With that said, I'm going to turn this over to Eric. He will moderate our last roundtable, and then we will wrap up, and we'll go from there. Thanks.
Before I unleash these 4 ruffians on you, I do want to say the Church of Scientology phoned and they want equal time. I'm a first-year law student here. To weigh in on the Mac PC debate, I was a devoted and now current jilted Mac user. I was forced to switch to PC by the law school's edict that all first-year law students buy an IBM-compatible laptop, and I'm acrimonious about it. And so Peter, I guess I'm the reverse of you. Just one procedural note. I want to try and move things along pretty fast. There seem to have been some dialogues that developed.
Where the question was, did they have jurisdiction over them? I think it's in New England state. I think Vermont or New Hampshire or something. And I believe, if I remember correctly, it was resolved by the fact that Hustler put its magazines in the stream of interstate commerce with either the intent or at least the knowledge, or at least they should reasonably have known that it would have reached places distant, including New Hampshire, Vermont, wherever else it might have. They were obviously profiting from that as a national acquisition, but most of our commerce today is basically national instead of international. And so they were held to be present wherever the magazine was. And it seems that that's in some ways analogous to what's going on when somebody puts a message on the internet. With maybe a slight exception of that, this is where I'm not sure how the technology plays. If you're trying to have a local user group of California people, but by virtue of putting a message or information within that California group, you at least open it up. Maybe you don't intend, but you at least open it up to use by anybody across the country. It would seem like it's possible that you should be held to standards for everybody.
Anyone want to try and wrestle with that?
It's unfortunate that Brock Meeks couldn't be here because this is exactly the Brock Meeks situation. Brock resides in Washington, D.C. He composes his CyberWire dispatch in Washington, D.C., and he was, of course, sued for defamation in Ohio. I've talked to Brock electronically. He's never been to Ohio. He has no assets there. His sole contact with Ohio is that presumably, this was never proven up because the suit settled, but presumably someone somewhere in Ohio received that message, and under libel law, the tort takes place where the defamation is published, quote unquote. If you think that receiving the message in Ohio means it's published there, then jurisdiction is proper. Of course, that means that Brock is also liable to sue anywhere in the United States, probably anywhere in the world. If you put something on the internet, no matter, even if you think it's in your own local Freenet or your own local listserv, people copy things, things get archived, they get moved around, and we all know or should know, right? That when we put a message out on the network, it could end up in, pick your favorite spot, Singapore. And are you then amenable to suit in Singapore? I suppose so. Now, ask yourself whether you really think about that every time you hit that send key, and whether you really want to be liable everywhere in the world every time you hit that send key.
Yeah, the international, there's two questions. I think the international jurisdiction question is different from the within the United States jurisdiction question, and I really don't know much about the international question. Within the states, the problem is the Supreme Court itself has been a bit divided, and it's divided on sort of precisely the issue of whether you must affirmatively seek to do something in another state, affirmatively seek to get business there or something, or whether it's enough to simply know that what you're doing could wind up there. And it's on those kind of issues that the court's been divided before cyberspace came up. And in a way, cyberspace is probably going to force a resolution of that because it's so terribly common to have that happen that maybe we'll get a resolution, but nothing the court has said very clearly marks the dividing line between jurisdiction and no jurisdiction.
If it's possible to be press the send key and be liable for libel in 50 states, doesn't have a chilling effect on the First Amendment, and if the First Amendment is indeed the First Amendment, wouldn't the court realize that, hey, publication should not occur in the state of Ohio because of the chilling effect on the First Amendment speech, because it's going to cause every user to double think and triple think. Do I press the send key?
Yeah, but you know, first, libel law, the First Amendment is balanced in the sort of actual malice standard, and what we're really talking about is the jurisdiction question, in which, I mean, one could bring the First Amendment into it, but traditionally the jurisdiction question, I think, hasn't really dealt so much with the First Amendment.
I'm kind of looking up here at the First Amendment. There are other more, the law can speak to this question more accurately than I have, but just to put the chilling effect, I mean, what's the layperson going to think?
Mm-hmm.
Actually, I'm not sure the law can. Most judges are pretty technologically ignorant, aren't they?
Federal Circuit.
You, sir.
I have a real hard time dealing with some of these issues. I think the SAM case where you're broadcasting a message is one issue, but I think the bulletin board case where it exists on your hard drive ready for someone else to dial in creates different issues. And I think in the case where your material exists on your own bulletin board and it is sought out by the Attorney General of Memphis, and I don't know the facts, but I'm positive that earlier that he dialed up once, he got it, and then he prosecuted it. I think there's, on that kind of fact pattern, I think that the community of cyberspace, if you will, I think there is a community, but I think it is a community of the loosest sort possible, and that there is no definition of a community standard, and that every user of the new network of the community has to be responsible for themselves and their own use, and that there is no external community standard because of the fact that there are no jurisdictional lines. You can be international, you can be national, you can be local, and you may or may not know the source of the material you're getting. I think you must be responsible for your own use, and I would like to see the defining standards as low as possible to say there is no responsibility above the user. The user is only responsible for himself.
You guys want to talk about defining standards? Being low or high, or your opinions?
I think your point echoes what Peter said earlier about AUPs, which is, you know, they're easier to draft probably, and they can be broader and vaguer if the responsibility is placed on the user to comply with the contract, if you will. And
do you all see a difference in standard of the internet versus the bulletin board? Do you mind analogy at all?
Well, I think you're correct. The amateur action case, which is the one you're referring to, is in some sense the flip side of the Brock Meeks case. Right? I mean, you know, am I liable if I put this out in the stream of commerce by hitting the send key versus I've got a bulletin board running and somebody logs on and reaches out from their jurisdiction and pulls it in. But it's very hard to tell where that line is drawn between, you know, affirmatively sending something out in the stream of commerce and simply sort of letting it drift into the stream of commerce. I mean, I was discussing this with some other folks about a week ago, and I said, think about this hypothetical. You know, the FCC doesn't allow certain material in broadcast at 730 words or whatever. Can I buy an FCC license, set up a radio station, put a tape into the machine with 730 words on a timer, and then walk away? And when it begins broadcasting, they come back and want to yank my license and prosecute me and say, "Hey, I didn't put that out there. I just kind of set up the equipment, and the equipment runs itself, and I have nothing to do with it." At some point, the owner of the bulletin board, the SysOp, is not going to be able to say, I think, well, I didn't hit the send key and actually send it out. I simply set up the facility that allows it to be distributed into commerce, and I sort of, you know, close my eyes and know nothing about what goes on in my bulletin board. I mean, that's a very difficult line to draw. because if we allow the bulletin board order to completely hide behind something like common carrier status, that simply encourages people to close their eyes to what's going on in the bulletin boards, right? On the other hand, if we set the liability standard too high, it's going to cause them to shut down the bulletin board. And we have to find some medium in between those.
But it does seem like there's a parallel with bookstores. I think somebody talked about earlier, what if you run a bookstore in California and somebody comes from Tennessee and buys a book? I don't think that's enough to confer jurisdiction. I mean, if they take the book back to Tennessee and it's obscene by Tennessee standards, I don't think they can get jurisdiction over you as a California bookstore. And I suspect it will come down to some sort of to likelihood. How likely was it when you set up your board that you would get calls from out of state? And did you know it was a high likelihood or low likelihood? And that's a pretty vague standard, but I bet it's going to come down to something like that. If you set up a board that you expect to be used nationally, you'll probably be held to have, subjected yourself to jurisdiction everywhere. And if you set up a board that's just in your bedroom and you expect people in your local town to dial in, you probably will not be held to have jurisdiction. The California case is an exception, but again, I believe in that case they mailed a video to Tennessee, and probably that by itself is enough to confer jurisdiction without any downloading at all. So I don't think that case is a clean case for the jurisdictional issue in cyberspace. And can I say one more thing? You were talking about communities, what the community standard is, and a lot of people active in this area are arguing that cyberspace is its own community or it has its own sub-communities that are independent of geography, and that we ought to treat those as the relevant community, so that it's totally independent of geography. And your community might be people who are in Hong Kong, or they might be right here at the University of New Jersey. And I think that we want to treat that as though if it was one
your time's up, sir.
I guess the truth hurts. Did you want to finish up?
I think I finished up.
Yes, sir.
I guess what I would ask, and I'm not sure if I understand the relationship between a publisher and a printer in either a pornography or a libel case. Would a printer be liable in an obscenity or a libel case, or is the publisher liable? And if so, is the SysOp operator, is he the printer or the publisher? He doesn't think in that situation, doesn't sort of put every individual in a position of being a publisher, and SysOp is merely my printer, just like if I go and print something out and distribute it.
I think the problem is, if you run a BBS or anything, you can be any of those things. You can be very actively involved in the selection and redistribution of messages. You can be tangentially involved. You can be totally uninvolved. And it's not enough. I think the people are typically talking about sysops, what are they? But you're really going to have to talk about what role are you playing as a sysop, because sometimes you might be active. You might screen all the messages, and sometimes you might not. So really, I think you have to ask another question besides, are you a sysop? You have to ask, well, what are you doing, and what do you know when you do that?
Sometimes the sysop may be the landlord who owns the building where the printing shop is located, right? You say, well, you should have known they were printing up dirty pictures in your building. You should have stopped that activity. Well, maybe, maybe not.
Jim?
As a member of plaintiff's bar, there's another fact that enters this whole thing. We always look for a plaintiff that the jury will want to compensate. Look at the amateur action case. Look at Ginsburg. Look at these cases and why they failed. Why Larry Flint went there. And Cincinnati incident, it started with himself, which is a non-market case. The one-person corporation, he owned a corporation. He was convicted not of consent, but of conspiring with this one-person corporation to
Distribute
property.
interstate commerce.
Right? To conspire themselves. Great case. But these people are unsympathetic plaintiffs. Now look at the case that came down in the last 2 years. The retired guy is harassed at the post office or there for a period of years. They finally ordered the kitty corner. He was a sympathetic plaintiff. They housed But unsympathetic claim.
I think you may be right, but we have to distinguish, I think, between the criminal side, which is really the amateur action side, and the civil side. I mean, traditionally, plaintiffs have been extremely, no matter how sympathetic they are, have been extremely unsuccessful in getting any kind of civil judgment for damages arising out of pornography. You know, you can look at the Hustler versus Herzog, or the Judas Priest case, or all these other sorts of cases, and it's extremely difficult to prove up damages or prove any sort of injury out of information. So I think you're probably right on the criminal side. I'm not so sure you're right on the civil side. I'm not sure we're ever going to see that happen on the civil side. It's cyberspace or elsewhere.
But a hypothetically sympathetic plaintiff would be a Freenet. It's a grassroots organization, no money, although its users can come from anywhere in the world because Freenets have varying levels of internet connectivity. Most of their users connect by a local telephone call dial-in. And the people that physically come together for the meetings held at a public library or school or a government building or an office or something drive locally, they put the machine together locally. So there is the geographic sensibility to it. And if someone happens to put something indecent or obscene on that system and someone complains from Memphis, one of two things can happen. One, it gives the system a black eye and loses community support. They can't raise money to continue and it fails. Secondly, the locals will circle their chuck wagons and say to Memphis, who needs your standards? This is Richmond, Virginia, and we have our own way of doing things around here. And that might be a hypothetical. That's different than the amateur action BBS.
Rick? I just, going back and you mentioned the Dobbins case, and I really wish this would have been one angle that we could have pursued a little bit more that unfortunately we couldn't. But in that case, they would have argued had it gone to trial, and they did, I believe, in briefs before the case was settled. The fact that anyone on Usenet, by virtue of their having the ability to broadcast information to an audience, is a public figure.
Yeah.
It's an intriguing concept, but I don't know that I've heard the angles fleshed out, and I don't know if anyone has some feelings on how accurate that assertion is, whether or not it could have succeeded in the court, and whether or not it ultimately could have prevailed on that issue.
There's certainly a good argument. I mean, one of the definitions or the factors in defining someone as a public figure. Making someone a public figure doesn't mean that they lose a libel suit. It simply makes it harder for them to win, kicks them into a different category. Mike Godwin at the EFF is the first person I know who sort of wrote up that argument in an article. The ability to respond is a factor in defining someone as a public figure. Access to the media is what the court has said. Those public figures are people who have access to the media. So it's a good argument, and it might work. Now, the thing is, of course, some people can be defamed over the internet who don't access the internet, and then it's just simply not available as an argument. But whether it be persuasive or not, it's also true that the truth seldom catches up with the lie, and even an after-the-fact response is good, but it's not the be-all and end-all of responding. So it's just a factor to consider. I lost my train of thought, but I think that will eventually be raised sooner or later. Who knows what as a blanket rule, I think people who argue it are saying it's sort of a matter of law. You should be a public figure if you're on the net, and I just don't think the court's going to accept that kind of standard.
Yeah, most of the public figure jurisprudence has arisen in sort of core political speech areas. The idea being, a politician has access to the media to respond, and the most important kind of speech to protect is this political debate. Whether that would be quickly extended to other areas, like discussions of whether or not this corporation's offer is a scam, is maybe a different question. Maybe that if you're going to have a political debate on the internet, fine, we'll call these public figures. If you're going to have sort of a private scuffle that just happens to be broadcast to millions of people, maybe it's not.
This is a little bit changing the subject. Looking toward the future of law, in the last roundtable, various references were mentioned to the technological knowledge or
Which judges are those?
Only 2 or 3.
That was my fault. I said something I shouldn't have said. Inappropriate on my part.
I was wondering if any of you had any thoughts on how that could change. How can the bench and the bar become more educated? I mean, do we have to wait? More college students now and law students have internet access like they did 20 years ago, or do we have to wait until students now are in those positions in order for that to happen? Or
I've actually done a fair amount on this in other areas, biotechnology, DNA fingerprinting, things like that. And I think everyone knows that there's a serious problem. Judges, especially the federal judiciary, are willing to struggle with these issues. They were mostly poli-sci majors or whatever, and they hate them. But they do their best. Usually, what you see is plaintiffs and/or defendants taking the time. In the Intel case, it was 6 weeks. 6 weeks intensive course for the judge on what microcode is and how you do semiconductor chip processing and so on, manufacturing. And that creates an enormous cost for the litigants to educate the judges. I think you're right, it would be nicer if we could educate the judges much earlier. The Federal Judicial Center has looked at this. By the way, their manual on scientific evidence is now available on their webpage. It's worth looking at. It's got chapters on what is computer software, how does biology work, how do you do econometrics, and so on. And this has been designed to try and be a resource to the federal judiciary in these kinds of cases. Part of what I think is going to happen is that when you have a highly complex subject, at least for the interim, we may have to look to specialty courts. That's what's happened, for example, with the patent bar. Patent litigation so often involves highly technical subjects that Congress said, fine, we'll set jurisdiction in a specialized court. Certainly not all the judges in the federal circuit have scientific backgrounds, but a significant number of them do, and they all have clerks. These are the law students. Right? They all have at least one clerk and usually 2 that have scientific training. And they've essentially become a specialty court. There are some other examples of things like this. We've done this for bankruptcy, right? We have bankruptcy courts. We may end up with, I don't think we want to end up with a science court or a technology court, but we may end up with a cyberspace court, right? Where the judges and or perhaps their clerks have the scientific training to deal with the issues.
Yeah, that's a very valid idea because there already is a tax court, a patent court, bankruptcy. Another alternative to specialty courts, or a supplement rather, would be for communities in cyberspace to use mediation and arbitration to resolve their disputes as opposed to going to litigation. And that's where MP10 will move in this direction. I've been meeting with the American Arbitration Association and some other individuals involved in international arbitration mediation, because although the American Arbitration Association has ancillary agreements with arbitration organizations overseas, they may not be the best organization. They've been around the longest, around 80 years. And they support the idea of using arbitration mediation in alternative communities, but they're at the beginning of the learning curve. So hopefully MP10 can supply to all the free nets in the States and then overseas as appropriate as possible arbitration mediation clauses for its AUPs between the SysOp and the users, as well as between the system administration and information providers, and then also between the system administrator and who they get their internet connectivity with, and then also who they get their phone lines from. So any point going into that computer has mediation and arbitration covered in it.
Just remember something I was going to say about the earlier point about the libel thing. Ellen Kirsch is the general counsel at America Online, and she's very much interested in this, and she says, I've heard her talk, and she has to wing it all the time because issues arise with America Online, and she's just guessing. But they got a threatening letter from a firm that claimed they were libeled on America Online. Somebody said something that was obnoxious, and they were upset about it. And she racked her brain for a while, and finally sent them a free membership to America Online and said, well, answer the charges. and they kind of went away, so that one worked. But I want to, on the matter of judges and specialty courts and so on, I echo a couple of things that are said. Generally in the U.S., we've relied on generalist courts, not on specialty courts. Most of our courts are general purpose. And I clerked for a judge when I got out of law school, and I learned that judges rely heavily on the attorneys to educate them, not just on the industry, but on the law, because you can't possibly know every detail of the law. And certainly if it's an industry, and like Dan was saying, you get semiconductor chips, the lawyers take it upon themselves to educate the judge. Now, and maybe they didn't in the Beep Memphis case, or maybe they should have, but I think you will find that attorneys will see that it's in their interest to educate the judge about the technology. And we probably don't have to wait for 20 years for judges to get on the bench who've done it independently. If they're good lawyers, they'll educate the judge. But the other thing I think is I like the idea of, I'm a big proponent of self-regulation and keeping the stuff out of courts in the first place, using arbitration and mediation clauses. And as a matter of fact, both Lexis Counsel Connect, which is owned by American Lawyer Media, people but American Lawyer, provides a cyber court dispute resolution mechanism if you want to use it, and the same mechanism is available on America Online. If you have a subscription to America Online, go into the keyword Court TV. These are the people who do Court TV. Once you get into the Court TV menu, there's a cyber court entry, and they have a little procedure. You may argue a case with them. They will provide, I think, anonymous referees or arbitrators who will issue you a decision. And you can do that right now on American Online. And they're treating it as a kind of, it doesn't have any legal significance, but they're treating it as like a little experiment. Let's see if you have a dispute. We'll resolve it with people who are comfortable with the cyberspace community. And I'd like to see more of that done, arbitration clauses and AUP agreements and that kind of thing, so we can kind of steer it out of the courts for a little bit.
Henry, then Peter. Sorry.
Maureen, on your point, I think, as speaking as a member practicing trial bar, I think you'll find that courts, judges are more sophisticated than people give them credit for. I think like Trotter and Dan have said, it is up to the lawyers to educate them on the law, and certainly if you're practicing litigator, you don't try the same kind of case every day. You yourself will get a case in an unfamiliar area, which then you've got to take it upon yourself to spend a lot of time learning about the technology. And I think that learning process begins with the lawyers and the judges alike. At the beginning, the minute that case is filed, you'll get through preliminary motions and that kind of stuff where the court will be learning about the law and technology just as the lawyers are doing that. And I think really the big question mark is not about the judges, but it's really about the jury, and that's where we get back to the issue of standards. Really, when we're talking about standards, we're not talking about some user in the abstract on the net. We're really talking about the jury that's going to be hearing the criminal or the civil case, and really you're taking a chance that they will understand during the duration of the case, whether it's a day or 3 months, what the technology is all about. And that's the real challenge. And it's incumbent on the lawyers and the judges, if they do their jobs correctly, to see that the jurors understand it. Because they're not going to hear anything about it, until they're in panel and the first witness is called. So,
Peter?
Going back to the cyber court idea, it's important to keep in mind that cyber court would not be adequate for the median if we're just limited to U.S. jurisdiction. Instead, going back to my company for illustration, if there's a dispute between an affiliate in the Philippines and an information provider outside of DC and a content provider who's related to one of our affiliates in Ireland, how the hell is people going to fly all over the place when the grassroots organizations have no money to fly or to pay their lawyers? Well, why not just use me and litigate or not litigate, but mediate in an online session, or just use internet relay chat and do it text-based. There's a record, you have a moderator. I mean, the technology is here, roughly. I mean, it's not slick, it's not perfect, but it's there to resolve disputes regardless of geography, location, and time. Just to find a time of the day when everyone's awake.
I think the only disadvantage of that is it's hard to interrupt the opposing counsel.
What's that?
It's hard to interrupt the opposing counsel.
That might be a benefit.
Oh.
Eric, let me mention just a couple of other things. It's true that good lawyers are going to educate the judge, but that absorbs an enormous amount of court time, and we've already got severely clogged state and federal courts. That may be the real advantage to systematic arbitration. Arbitration is really just litigation, it's private litigation, and since you're paying for the judge, you can select a judge who's knowledgeable, and you bear the costs rather than the taxpayer bearing the cost of having that forum be available. Some things are not going to go to arbitration because the parties can't pay for it or won't pay for it, or it's criminal prosecution. It's going to be in the state or federal courts. There are some other mechanisms that are being tried. One is the use of special masters. The judge may not be an expert on this topic, but he can certainly find a special master who can do the findings of fact on the technology and report back to the judge. That's a possibility. The federal judiciary certainly has that power to use those special masters. Some states do also. The other is court-appointed witnesses. It's federal judiciary and many states have the power to appoint a special witness, a technical expert, who can advise the judge in the background. Some people are worried that that sort of isn't sporting, it's not part of the adversary system. If that's really a big concern, the witness could simply prepare background material for the judge rather than testify before the jury. One of the things they're concerned about is that this is the court's or the judge's witness, and so it's going to sway the jury unduly. Well, keep the special technical person in the back and just let them do background for the judge. That may work also. The Federal Judicial Center actually did a survey of judges, federal judges who used this power, which is available under the federal rules, to appoint a court-appointed expert. The judges who had done it were uniformly happy with the results. Very few had done it comparatively, though. And when they were asked why, they said, "Well, we think that it interferes with the adversary process. We're reluctant to, be more than the referee. We don't want to be too involved." That model may have to change.
I'd also add that the local rules in some federal districts now require mediation. So. May not get around it anyway.
30-day mediation, report back to the judge before he's around.
We've only got a couple more minutes left, so any last, I won't say parting shots, but parting shots?
I'm not sure that there's any good way or good reason to ban anonymous digital cash because, dollar bills are anonymous pretty much. And I don't see that that's very different. And so I'd be surprised, actually, if we limited the exchange of digital cash. Digital cash is a technology that allows you to buy stuff over the internet with cash. It's not, obviously, you're not literally sending folded up dollar bills, but it is the equivalent of cash in that it is untraceable. It's not like a credit card ID. You are not identifiable. It is a way of doing a transaction that is just as anonymous as walking into a store and giving them cash. All right, so that's coming. And I think that'll be allowed. Anonymous messages, it's also possible to send email through what's called an anonymous remailer. It's a computer system that strips off all your identification and then forwards the message on, and it can't be traced. And if it can be traced from one, you can do it through 2 or 3, and you can send it's anonymous. I personally think as soon as somebody uses that mechanism to blow up the UN or something like that, they'll make it illegal, and then it'll be a question of if you can successfully make it illegal. And it's a hot discussion on the internet as to whether that should happen or not. That's my view. I think people will try to ban it as soon as something bad happens with it.
I've been involved in several of these discussions as well, and I've sort of come away ambivalent about anonymous postings. What is clear to me is that there are obviously places where you would want anonymity, maybe in some political forum. If you're going to vote online, obviously you don't want your name attached to that for secret ballot. Some people have suggested that there are 12-step groups, recovery from abuse and things where you want to be able to have anonymous postings. Those might all be legitimate uses for that. There are going to be other illegitimate uses, maybe not to blow up the UN, but to defend.
Well, that might be okay, actually. I'm at World Trade Center. Yeah.
There you go. Yeah. But to defame people or whatever. And it's not clear to me, as Trotter says, that even if it is put to a bad use, that you're going to be able to stop it. It will simply move offshore. the only way to possibly stop it is to turn it into sort of an international crime like terrorism or piracy, to where it's fair game for any country that wants to go after it. And I guess we can send the bombers to Libya to wipe out the anonymous remailers, that are housed there, right? But you're going to see that. You're going to see things move offshore. Some countries are going to want to attract these kinds of things. Some countries are not going to want to have them. And we're going to end up again in the realm of diplomacy and sort of international trade sanctions and those kinds of international pressures to stop it. Probably not what we think of as legal remedies.
Peter, you have something to add, and then we're going to have some closing remarks.
About digital cash in electronic communities. I think digital cash is actually a pretty regressive idea in the sense that Walter Wriston, the former chairman of Citicorp, said a couple of years ago actually that computers and information technology is progressing at the time he said this at such a fast rate that money is not valuable anymore. Information about money or information about data, knowing when something is going to be released, if you have that information first, you can make a move. And the fact that you can facilitate these moves by computer technology or block our companies from making moves by taking away information on their hard drives and all this hacker stuff, I think is far more viable than digital cash. I think a lot of legal paradigms are going to begin to change. Copyright is one of the first ones. What is money and commerce? I don't know, maybe the people who built the net watched too much Star Trek in the 60s, because a lot of things you see on the internet today, which has some frightening parallels. I mean, you see Apple's Newton pad and these handheld palm-top computers and things. But what about, there's no cash in the future. What is the value? Well, they have access to computers that can create tremendous amounts of data. Even data doesn't exist on a holodeck. I mean, anyway, this is getting way out in the future. Yeah.
Okay, that finishes up this roundtable. Rick?
I just have a few quick closing remarks. First of all, obviously, this symposium could not have happened without the incredibly talented speakers that have come today, and to everyone that has participated, including the four gentlemen up here. I personally extend a tremendous amount of thanks for participating in this. They had weather to contend with, they had a Saturday to give up, and in all respects, I think they did a tremendous job, and I'd like to thank them. I also, to name every person on the LTA that has helped out would keep us here quite longer than any of us want to say. But specifically, there are two people that this literally would not have happened without them, and it's Maureen Stinger and Eric Link. Over the last 3 weeks, as my energies have shifted to the journal, they have basically taken over this project and have done a fantastic job. And please, everyone, as you go out, give them a hand and also thank them. Finally, thank you. This would have looked real silly without people in the audience to listen to those of us speak. So the participation here has been outstanding. This has been thrilling for us to put on an event of this magnitude and actually have people come out both locally and again, those of you who drove great distances, makes us all feel real good that you felt the need to come out and be a part of this. So thank you to all of you. For participating in this. We hope to do it again. We will keep in touch with all of you by email, and I think we've started some discussions. We haven't gotten the answers, but I think we're probably a step ahead of most people because we're at least identifying some of those questions. Jim, you're...
This was for every mile of freeway I looked at the past 3 days. Every mile.
Thank you.
So if you do it again, make sure you tell me.
Thank you. Thank you. Goodbye, everybody. I really appreciate it.